A very good afternoon, everyone. We're delighted today to welcome for our 7th webinar our colleague Henry Pierce, Dr. Henry Pierce from the University of Portsmouth. Henry is a senior lecturer in law at the university. He's previously worked as a lecturer in law at the University of Hertfordshire and was a visiting lecturer in law at the University of Southampton. He's also the deputy editor for Computer Law and Security Review, an international journal of technology and law practice. As you're going to see, Henry is an expert in data protection law and everything going around it. So I'm sure you know this quote. This is one quote we often refer to when we talk about what's going on today, and generally when we talk about data protection. If you keep a secret, or if you want to keep a secret, you must also hide it from yourself. And I'm sure you recognize this quote from 1984, George Orwell. So is there any secret today? Can we keep our secrets? How do we do that? How do we protect our lives, our private life, our data? This is precisely what our colleague Henry is going to address today during this webinar. So let me remind you a few rules. First, please kindly mute your mic so that we don't hear everything around you. And then if you have questions, once Henry is going to be done with his presentation, please write them down in the chat box so that I could read them out to Henry. Henry, without further ado, the floor is yours.
Well, thank you very much for the very kind introduction. I don't think I've had an introduction quite that nice for a very long time. And thank you also for inviting me to speak to everyone today, and thank you to everyone for joining. I will just try and share my screen with you so you can see what I'm going to be talking about. So the interdisciplinary nature of my talk today will focus on law and computer science. The legal side of this will be a discussion around the Freedom of Information Act and how it has been impacted by developments in computer science, namely in the area of anonymization, and why developments in this area have necessitated the need to develop a new approach for how data and information are disclosed under the Freedom of Information Act. So moving the slide on. So basically the structure for the talk today, what I'm going to talk about is to explain what the Freedom of Information Act is and its relationship with this concept of personal data. We'll then move on to talking about the computer science side of things, anonymization and the limits of anonymization techniques, before putting these two things together to explain why the latter creates a problem for the former, and then a possible solution for this problem that I've devised, and finally we'll talk about some other issues that link all the things that I've talked about today to other salient topics that are being discussed in the discourse at the moment. The starting point for the talk is this legislation, the Freedom of Information Act. The main thing this Act of Parliament does is give individuals a general right of access to information that is held by public authorities. So it gives us all a right to go to, let's say, a local council, the BBC, a government department, the NHS, and request information that is held by that whatever institution. And the recipient of a Freedom of Information request, assuming no exemption applies, has a legal duty to disclose the requested information to us. This legislation exists as a means of giving effect to political accountability and transparency. It's an administrative law tool, really. But the significant thing for what I'm talking about today is that the disclosure model utilized by this legislation operates on a so-called release and forget basis. So what this means is that once a public authority discloses any information or data under the Freedom of Information Act, there are no post-disclosure obligations or controls that are attached to any of the information or data disclosed. So the recipient of any information disclosed following a Freedom of Information request is free, unless any other legal rule applies, to do whatever they like with that information, that they're under no obligation to store it a certain way or not to use it for a certain purpose. And the releasing public authority also has no responsibility to monitor how any recipient of the information it discloses uses that information. Significant, however, is that personal data, which are generally speaking any information relating to an identified or identifiable individual, are generally exempt from disclosure under the Act. The reason for this being that personal data are very sensitive potentially. In the wrong hands, they can be used for all sorts of nefarious or harmful purposes. And so you cannot request personal data under the Freedom of Information Act because, affected persons, their data protection interests may be compromised. However, anonymous data, which are data that are not reasonably likely to identify a person, are not personal. Therefore, they're not covered by this exemption. So whilst personal data cannot be disclosed under the Freedom of Information Act, generally speaking, anonymous data can be. So often what public authorities will do are anonymize personal data they have through the use of so-called anonymization techniques to render them anonymous, and then the exemption will not apply and those data can then be disclosed. Is a word we are hearing more and more about particularly in these times. Particularly in discussions relating to NHS tracing apps and so on, which I'll come back to a bit later. But it is not a one-size-fits-all thing. There are many different types of anonymization techniques. There are some examples of popular ones on the slide. Some offer mathematical guarantees of anonymity. Others do not and work in slightly different ways. But there are lots of different techniques that you can use to nominally anonymize personal data that is at your disposal. However, developments in this field, in the field of anonymization, which I'm not going to get into in a huge amount of detail because it's very technical and would take a lot of time. But the upshot of a lot of work done in this area has shown that the idea of complete, irreversible, total, 100% perfect anonymization is a myth. It cannot be done. There is no such thing as data that are completely anonymous in any context. The reason being, or one of the reasons being anyway, is because of various technological developments like the emergence of so-called big data, the cross-analysis of a data set that has been nominally anonymized, let's say by one of the techniques mentioned at the top of the slide here, say k-anonymity, can result in those data being de-anonymized. So anonymization is not a perfect technique because no matter how you do it, chances are down the line, in some situations anyway, as we'll talk about in a moment, anonymized data can be de-anonymized. And if they are de-anonymized, they will become personal once more. It's a bit of a problem in many different areas of data protection law and freedom of information law. But one significant issue is it raises this question of whether or not it really is appropriate for data that are nominally anonymized to be disclosed on a release and forget basis. The reason being because let's say a public authority receives a freedom of information request in relation to what it considers to be a legally anonymous data set and discloses that to the requester under the Freedom of Information Act. It may be that at a point in time later down the line, those the data that the public authority thought were anonymous are de-anonymized and made personal once more. So we can ask, is it really appropriate for the Freedom of Information Act to allow for anonymous data to be disclosed in this basis? Because there's a chance a lot of the time that those data, if they remain anonymous, okay, yeah, not going to harm anybody if those are processed because you can't link them to a specific individual. But if Post-release, they become de-anonymized. There is then a chance that those data, because they're personal once more, could be used for very harmful purposes, like identity theft or profiling or something like that. So it really does raise the question of whether, because under the Freedom of Information Act, if you release data on a release and forget basis, you're basically releasing it to the whole world with no restrictions. It becomes open data. Well, we have to ask, is this appropriate? I would argue it absolutely isn't. This is not something that is appropriate at all. This whole idea of release and forget and operating on that basis is premised on the idea that anonymization is perfect and that there's no danger that can stem from the processing of anonymized data. But actually, this isn't the case. The opposite is in fact true, and therefore a thorough rethink of how information and, or at least certainly anonymous data is disclosed under the Freedom of Information Act is required. So we've presented the problem, and I suppose because I've done that, I am to some extent duty bound to present a solution. So significantly, whilst perfect 100% infallible, irreversible anonymization that ensures data are anonymous in all contexts, anywhere ever, is not possible, functional or so-called contextual anonymization can still be achieved. So for instance, if I were to release a nominally anonymized data set to the entire world, chances are there will be somebody out there who can de-anonymize it. There is a huge risk that that will happen. However, if, let's say, I have the same data set and I release it on a restricted basis only to a select group of individuals with conditions attached that prevent certain uses of the data in the future, the risk of de-anonymization is much reduced. It may even be zero. So whilst releasing data openly on a release and forget basis may have a very high risk of de-anonymization a lot of the time, releasing it on a controlled basis may not give rise to the same level of risk. Whether anonymization is effective will depend on context. It will depend on who is receiving the data, what the data are going to be used for, who has access to the data, what security measures are in place, etc., etc. And there is no reason, I don't think, why the Freedom of Information Act's disclosure model could not be reformed to encompass this nuance. Instead of having a one-size-fits-all release and forget disclosure mechanism, we could instead have a more a disclosure mechanism that operates on a gradient, on a spectrum, depending on the level of risk associated with the disclosure of those data. So my whole idea, really, to provide a solution to this problem, is for a licensing scheme based on the risk of de-anonymization associated with data held by public authorities to be introduced and slotted in either in replacement or alongside the current one-size-fits-all disclosure model. So there are two main stages to this, really. To be able to assign a license to data that is nominally anonymized pre-disclosure, we need to be able to calculate the level of risk associated with the disclosure of that data. The way through my research, there are two main considerations that can inform the level of risk associated with the disclosure of anonymized data. One of which is simply the probability of data being re-identified, and irrespective of the probability of data being re-identified, the sensitivity of the data and the impact that re-identification might have on an affected individual were it to occur. So once we can work out the likelihood of an anonymized data being re-identified or de-anonymized, as well as the possible impact that that re-identification may have on any affected individuals. On a scale of low to medium to high, we can work out different levels of disclosure, which can be plotted on the matrix that we can see on the that can be shown, that's shown on the slide. Moving to the next step, my idea would be, once you are able to calculate a holistic level of risk associated with the disclosure of any anonymized data, which you could do through a matrix like this, would be to license to those data depending on where it comes out. Its disclosure can be plotted on the matrix. So in a similar sort of way to how Creative Commons licenses work in the context of intellectual property, my idea essentially is that anonymous or anonymized, nominally anonymized data should be disclosed under the Freedom of Information Act, based on a licensing basis, depending on the level of risk associated with the disclosure of those data. So, for instance, according to this, the spectrum I've come up with, if the overall risk associated with disclosing an anonymized data set is very low, then there's nothing wrong with necessarily releasing those data on a very relaxed basis without any kind of contextual controls attached to those data, on similar to the release and forget basis we have now. If we rise up to more moderate risk data, however, whilst it might be the case that it would be inappropriate for those data to be released completely openly, it may still be possible for those data to be released on a very limited basis. So, for instance, you might be able to release a data set to a restricted number of parties with conditions that say something like, you can't share this with anybody else, you can't use it for certain purposes, or you must only use it for very specific purposes, with obligations attached which would prevent any serious re-identification risks occurring. At the other end of the spectrum, we may have very high risk data which should not be disclosed in any circumstances. So, because anonymization is a very context specific thing, this idea is designed to marry up the law with the computer science that is affecting it. If anonymization is very context specific, and whether data are anonymous is very context specific, this is the law, the disclosure model of the Freedom of Information Act should reflect these contextual peculiarities and operate on this basis. This would allow for data that should be disclosed for valuable and useful purposes to continue to be released, whilst also protecting the data protection interests of any affected individuals. How am I doing time? Okay, so yeah, so the solution to this problem that I have come up with and have written about is this, risk-based licensing spectrum that allows for anonymized data to be disclosed in accordance with the contextual particularities of those data. So in order to test this idea, I have been out and spoken to various experts in the field of law, data governance, computer science, philosophy and public policy, and pleasingly, the feedback I've received from almost everybody I've spoken to when testing this idea has been positive. The general consensus appears to be that this way of doing things would definitely represent an improvement on the current model for disclosure under the Freedom of Information Act, which is, I think, widely recognized as being deficient, and that this would help bring the law into closer alignment with the science, the computer science that the law is regulating effectively. However, whilst generally speaking, this model has received positive feedback and positive comments in terms of how it would represent an improvement, there are some challenges that would be inherent in its operation. So There is no denying that operating a licensing system like this would be extremely complicated. It's a very complex thing. Determinations about when and in what circumstances anonymization efforts might be successful require a lot of expertise. Closely linked to that are ideas of cost. Introducing this system would not only put a lot of financial burdens on public authorities, but also on the regulator, the Information Commissioner's Office. Non-compliance is another issue, because no matter what terms of licenses might say, people may just choose to ignore those licenses. How they could be enforced and what the penalty for non-compliance would be is another issue. And the final major issue that would likely to come up would be ethical and theoretical objections from people such as open data advocates who may, erroneously I would argue, but may view this system as an attempt to restrict open data and put a fetter on freedom of information. So there are, whilst there are positive feedback that I've received in relation to this system, there are many challenges as well. So just moving on today, which links some of the things I've spoken to in a general sense to specific ongoing issues at the moment, is that I mean, I've spoken about one issue where anonymization and developments in this area have posed a problem for the law, but there are many others, and this is something I alluded to earlier. One particular area where anonymization is again receiving a lot of attention is in relation to the NHS COVID-19 tracing app, which is designed to, well, yeah, it's been designed to trace the spread of possible COVID-19 infections. So one thing we have heard a lot about is that any data collected by this app will be anonymous. We've seen particularly Matt Hancock talking about, oh yes, it's totally anonymous, fully anonymous, and things like this. However, it has been demonstrated by various observers how actually, even though the data gathered by the app will not necessarily identify individuals directly, the data, when collated, may mean that individuals are still identifiable, even if they're not identified. And as I mentioned at the beginning, data will be personal if they are identifiable. So legally speaking, the NHS app does not guarantee anonymity. So despite constant reassurances that, if you use the app, your data will be anonymous, well, legally speaking, they absolutely won't be at all. So there is an issue there. Other concerns with this app linked to decentralization and trust and function creep. There are many particular concerns about the app that I have, and I won't be using it if I can get away with that. But yeah, anonymization is a broad topic, and it just goes to show that there are many areas of application where it is becoming increasingly relevant. So yeah, I think I've probably said all I was going to say. So thank you very much for listening, everyone who has joined. And yeah, I hope everyone found that interesting. And I shall happily hand back over to Layla to for questions or general chats and whatever else is next.
Fantastic. Thank you so much, Henry. That was absolutely excellent, fascinating, extremely clear. So this is a message to everyone. You see, lawyers are extremely clear and it's easy to study law. So please do come and study and listen to our webinars. But I have a few questions for you, and I'm sure everyone's preparing questions. Remember that you have to use the chat box to ask your questions to Henry. The first question I have, Henry, for you has to do with this risk assessment that you've designed and explained to us. This is something we see a lot in law, I must say. We're quite familiar with that. You know, for instance, in the context of businesses and human rights, we have what we call the due diligence, which is quite popular at the moment. It's been integrated in a number of contracts or treaties internationally. So basically, before you invest abroad, you do a due diligence risk assessment. This is extremely controversial, and the reason why it's controversial is because of the who, and this is exactly what you ask, you know, the sort of ethical legitimacy. So in your model, who would be performing this risk assessment?
So the risk assessment would be done by the public authority receiving the request. Any decisions the public authority made would be you would be able to appeal to the regulator, the ICO, which is how things work already at the moment. There are problems associated with getting the receiving public authority to do the risk assessment. There's definitely a concern they may, I don't know, have a vested interest in the outcome. They may not have the expertise to make the risk assessment as it is at present. One thing that was suggested alternatively by one of the people I spoke to and doing interviews to look into how this could work was getting the individual making the request to do the risk assessment. But again, there are possible conflicts of interest and things that would arise there. Individuals also may not have the expertise to undertake these assessments properly because they're very technical. One other step in this process that I didn't mention for the sake of time really is that when it comes to anonymized data and making freedom of information requests in relation to these, another step that could also be introduced is a requirement that any applicant states their motivations and intended purposes for what they're doing, because deciding whether or not an anonymization is going to be successful, you need to know the context. You need to know, so for instance, using dataset A for purpose X might not be harmful at all, but if it's used for purpose Y, that's a big problem. So if the person making a request says, oh, I'm only going to use it for purpose X, that's fine. And if you know that, you can say, right, okay, now that we know that's all you're going to do, we can say, yes, you can have it under license as long as you only do the thing you say you're going to do. So it would be the public authority who would make this decision, but to avoid problems, this would be appealable to the regulator, which is, yeah, similar to how things are done now. This wouldn't necessarily be a perfect way of doing things, but I think it would be the best way, so far as I can tell.
Excellent. Thanks very much, Henry. I have another question which relates, but I'll ask it later. It's about comparison, international comparisons. But we have a great question from our colleague, Professor Adrian Opgood, who happens to be the theme director for Future and Emerging Technology.
Okay.
So very much related to your work. Thanks very much again, Adrian, for being here. So hi, Henry, a couple of points. First, blockchain is overhyped. IMHO, you know what it means, but I guess as a role in your license model. So does it have a role in your license model? Second, I thought a common way of depersonalizing is to aggregate data with others. So personal information is diluted in that way.
Yeah. Yeah. First of all, I definitely agree that blockchain is overhyped. I think it's kind of become the modern day equivalent of snake oil almost. You see it touted as solutions to everything, and I think there's a lot of doubt to be had about how useful it is. I suppose there is one that there would be a possibility of using blockchain in a sense. I mean, I don't think I would necessarily agree with it, but it could be used as a way of monitoring subsequent uses of data and creating a permanent ledger that shows what is done with data in the future. That there are many problems inherent with that proposal, I think, but it is an idea that even if I'm not a big fan of it, I think you wouldn't struggle to find people who would also say this is something worth exploring, and there could be a use for blockchain here. And yeah, aggregation as a way of de-anonymizing the data is definitely a way. It's a type of yeah, it is a form of anonymization. I think one or two of I can't remember which ones I mentioned on the slide now. There are some of the techniques I looked at when examining the technical side of things here were types of aggregation. I think there were various types. So aggregation is definitely one way you can de-anonymize a data set, but it's like various other techniques is susceptible to certain types of de-anonymization risk. So whether or not aggregation would be an effective way of anonymizing a particular data set in a particular context would, again, depend on the contextual nature of what the data is, who it's going to be shared with, for what reason, and so on and so forth. So I'm not sure if I've actually answered the question there, actually, but I think I don't know, said something about it anyway.
Well, I think you have, but Adrian, do you want to take the floor for a while, or do you want to say something to add up to either your question or what Henry just said?
Sure. Hi. Thanks for your answer then, Henry. Yeah, on the blockchain thing, well, yes, we've both said it's a bit overhyped, but seems to be a solution looking for a problem often. But in this particular case, since you were talking about tracking who was using the information that had been released, I just thought there may be a role there. Which you kind of acknowledged. On the other thing about the aggregation of data, I suppose that's just a reflection on some experiences of mine in the past when I've been in sort of university management roles and have had to respond to requests, often requests about salaries as a common one, particularly in universities when sometimes the press feel that some people are being paid too much, which is they may or may not be right. And to avoid revealing personal information, I just saw that what was typically done was to say something like, you know, there are X number of people earning a six-figure salary or whatever. So it sort of it doesn't reveal too much about any individual one, although it does give a sense of how many high-earning people there are in the organisation.
Yeah, I think that's right. The limits of aggregation, it would the problem with using aggregation as a technique is that it's fine unless you have access to, let's say, two different data sets, and from one you can kind of begin to piece together the two. You can work out, it's a bit like playing what's it called, the board, well, not really a board game, but Who's Who. If you start working out, okay, there's X amount of people in one data set, but with redacted names and maybe gender or age, if you have another comparable data set, you can start to infer who is who in relation to, you can start to narrow down who within the aggregated data set, let's say record A, might be. And then once you narrow that down to within a sort of a specific, I don't know, a reasonable probability, then the data becomes personal again. So it's definitely worth doing, but there are different types of re-anonymization risk. Some will be some types of anonymization, like aggregation, will be susceptible to some, whereas others will be susceptible to others. And when working out whether or not what you've done is enough to render data anonymous legally, will depend on exactly which risk your data set might be susceptible to. So yeah, like you say, an aggregated data set might not pose any risk if you release it to somebody who has no background knowledge of who might be in it. But if somebody does have background knowledge and or access to some other source of data that you can cross-analyze, you can begin to unpick the aggregation. So yeah, strengths and weaknesses, basically.
Okay, thanks very much, Henry. That's great. While I've got the microphone, can I actually make a third point, which is just an observation, really? I saw your matrix, your risk matrix, where you you had your sensitivity of the information versus the risk, the likelihood of it being sort of revealed. As I think that was.
Yes, yeah, that's right.
It just struck me that the way you'd drawn your matrix, there was equal weighting on each of those two axes, and I was just thinking to myself, well, actually, possibly the sensitivity is the more important axis. So if you've got some really sensitive data, even if the likelihood of it being exposed is low, you'd still want to see that as high risk, if you see what I mean, because the sensitivity is more important. It's particularly important.
Yeah, I mean, I guess with these things, it's one analogy that kept coming back to me when designing this was that it's almost like the risk of a nuclear power station exploding. The likelihood might be very low, but if it actually happens, then it's absolutely catastrophic, and therefore even if the risk is very low, you still need to take the utmost precautions with it.
That's exactly what I meant. Yeah.
So yeah, I fully appreciate that, and I think that there is, when it comes to conceptualizing, I mean, the probability of re-identification on one axis is not too much of a problem. You can make a fairly good stab at these things, but determining the impact re-identification will have on any affected individual is much more difficult, because different people will have different ideas about what a tolerable risk is. And you never really know how much something will impact on somebody else. So this is a limitation in that framework, I think. The reason why there are only 3 gradients, sort of medium, high, medium, low on each of the axes, was largely based on a survey of other risk management methodologies and data protection impact assessment methodologies that are used in various jurisdictions around the world, really. So when devising this, I looked at how things are done in France, for instance, and how things are done in the USA, and a range of methodologies. And whilst all of them either explicitly or implicitly alluded to exactly the issue you've just mentioned, they all tend to agree that even if there can be more nuance to it, it's possible to group harms within a sort of high, medium, low sort of range. I completely see your point, though, and I think there is more nuance to it. There are different types of harms, and they affect people in different ways, and people have different ideas about what is acceptable harm and what isn't. So I think, one of the findings when completing this project and writing it up was that there is more to be done there, just simply, almost from a totally philosophical point of view. How do we really conceptualize risk and harm in these situations? So I think, there is, it's in some ways it's a little ham-fisted at the moment. So I think we could, flesh it out a bit more, but beyond the scope of this talk, maybe.
Yeah, thanks very much. I wouldn't describe it as ham-fisted, but thanks very much. I better let somebody else comment. Thanks a lot, Henry.
That's okay.
Thank you very much, Henry. That was really excellent. We got another question from one of your colleagues, I suppose. This is Edina Arbinja, so from Aston University in the US. And she says, hi, Henry, great to listen to you as usual. I really like the licensing spectrum and your model. I wonder how you assess the sensitivity of the data in your grid, and to what extent are these similar to special categories of data in GDPR? Which special category GDPR data would be more or less sensitive there?
Yeah, this is a question as well. I think that ties into what I was saying a moment ago almost. The difficulty with it's, again, I think that part of the axis is not a perfect scale. What I wanted to do initially is calculate the impact de-anonymization may have on any affected individuals. And that is a very difficult thing to do, because different types of data are more valuable to, people are more interested in certain types of data than others. So some people may say, oh, it's my financial information that's most important to me. Other people may say it's information about my health that's more important. So working out like a sort of a level of harm, it really depends on the individual. However, sensitive or special category data as defined in the GDPR, I I can't remember exactly how I argued this, but I argued that these are the types of data that are typically more likely to be the most harmful, because when used for erroneous or nefarious purposes, so health data, data about sexuality, political views, these types of things. So my approach to this in this situation would be for a public authority, when it comes to categorizing the impact re-identification might have, would be to try and, as best as it can, work out what impact will, if de-anonymization happens, what impact will this have on the individual. That's a very difficult thing to work out. And if a public authority cannot do that, my advice would be, right, well, the next best thing is to look at the categories of data set out in the GDPR, and the more sensitive, according to the GDPR standard, a type of data is, the more likely it is to be high risk. There are nuances within that, though. I mean, just to use an example, I suppose most people I would probably say, would be less worried about information regarding, let's say, their email address, their contact details possibly being disclosed, than they would very sensitive details regarding their health, like whether they were HIV positive, something like that. And I can't remember where I was going with that point now. I've lost my own thought process.
What's sensitive, what's not, I suppose.
I suppose so, yeah. I think using the GDPR's definition of sensitive data as a guide is the next best thing to do if you cannot work out definitively in a case-by-case basis what would likely affect this individual most. Again, this isn't a perfect way of doing things, I don't think, because risk is well, in any context, in any area of law, risk is a very strange concept, I think, because it means different things to different people. And I think, as I mentioned before, even if you can calculate the probability of a risk, different people have different ideas about what a tolerable level of risk will be. Some might say, yeah, it's okay to do something if there's a medium risk. Others say, no, we need to have a low risk before we go ahead with doing what we want to do. So I think risk and the law is a really interesting thing, regardless of application, really. And there are many problems with this concept of risk itself and how it works as a legal value. And I think here is just another area where a really sort of detailed thinking, some real deep thinking about how we can reconceptualize risk and think, well, what actually does it mean in this context, would be really useful.
Absolutely. Thank you so much for that again, Henry. We have time for more questions, really, probably two more questions. I'm going to ask one. Risk in law, as said, is really complex. We often talk about legal certainty, which often, sounds strange to me. I don't know what's legal certainty. I think it doesn't exist at all. But do you have benchmarks, comparison? Who's doing better than we're doing in the UK?
In terms of anonymization generally, or just in the freedom of information context?
Yeah, I would say both, and probably like the whole issue of data protection, protection of our private life, and indeed data.
I think the most, as far as I'm aware, from a computer science point of view, and how risk assessments of anonymization can be undertaken, I think the UK is probably ahead of a lot of people at the moment. The UK, the leading sort of literature on this area on how to undertake risk assessments are in relation to anonymization and how anonymization as a concept should be understood. The leading literature on this has been created by the UK Anonymization Network, which is a collection of academics, mainly, I think, hopefully I'm not going to leave anybody out and offend anybody here, but mainly from University of Manchester and Southampton. Their literature on this is that they take a very forward-looking view to anonymization, which is very much that well, actually, to go back a step, anonymization has historically been treated as an exercise of looking at anonymized data in isolation. If you want to work out, are data anonymous, you look at a particular database, data set, and go, yeah, that looks fine. But actually, what they have quite convincingly shown is that it's not enough to look at the data themselves. In order to work out whether a data set is fully, well, it is anonymized, you have to be aware of the wider context. It's no good just focusing on the data. You have to ask who has the data, who's using them, what are they using for, who can access them, etc., etc. And they, as far as I know, and I think other people are beginning to catch up, this is the foremost, this is kind of the authority in the area now. So far as other jurisdictions are concerned, you can kind of see in France in particular, the regulator there is that they have a similar methodology that bears some similarities, but most regulatory guidance from other jurisdictions that I've seen focuses on data protection risks more generally rather than specifically anonymization. And I know that the UK Anonymization Network has begun to export their framework for how to do these things to other jurisdictions as well. So I think in that sense, the UK is perhaps ahead of the curve. Certainly seems to be the leader in the field, but it does seem that, yeah, it's, despite anonymization itself being a fairly underdeveloped area, I think people are beginning to wake up to this now and realizing this is a serious issue, because the whole of data protection law is premised on there being a divide between personal data and data that are not personal, but that divide has now become very blurred. It's not a dichotomy anymore. There's lots of grey areas. So I think we're going to we'll see in the coming years this problem becoming more of a practical one rather than just a purely academic sort of theoretical one.
Absolutely. Thank you so much again, Henry. We have the last question from a colleague from a college in Brighton who's a law teacher there. I suppose your name is Lion, or I'm sorry if I'm not pronouncing it well because I don't see much of your name, but thanks very much for your question. So this person thanks you. Really interesting ideas discussed. Would you envisage there being a similar scheme of fines or sanction as exists under the Data Protection Act 2018 for any breaches of the rules under such a licensing scheme for freedom of information requests?
Yeah, the one interesting question that came up when devising this system is that, I guess with any kind of system of law, there must be some sort of penalty for non-compliance. The question becomes, I mean, I think I mentioned a bit before about how that could be enforced and so on is an interesting one. But one thing that was flagged in the testing for this system when interviewing respondents was, well, clearly there must be liability for people who just ignored license terms or didn't comply with them for whatever reason. And the question then becomes, well, what kind of liability are we talking about? Is it going to be a civil liability thing in terms of like with intellectual property violations, for instance? Or should it be criminal liability? And one person I spoke to was very adamant that anyone who breaches license, they should be punished to the full extent possible. Should be a criminal offence. This is really bad stuff. And there's some appealing. I can see the appeal in that approach, and I think we are seeing at the moment a trend towards the use of criminal penalties for data protection issues. The Data Protection Act 2018 introduces a range of criminal offences that stem, that link to data protection issues. In fact, one of the new criminal offences contained in the Act is either deliberate or reckless non-consensual de-anonymization of anonymized data. And that's there is some legs to that, I think. The problem being, however, is I'm slightly reluctant to, I'm not fully comfortable with the idea of using criminal law to solve data protection issues. The reason being that the use of criminal law in relation to using it as, let's say, a penalty for certain behaviours, it requires the existence of use and use of clearly established social norms which don't really exist in the data protection context. What we would have is a very sort of specialized level of crime, sort of comparable to cybercrime, I suppose, which may have to compete with quote unquote normal crimes for resources and enforcement. And by and large, with these kind of things, this is a very, as I mentioned earlier, anonymization is it requires expertise to be able to do it properly and understand it. And by and large, the type of expertise needed to do that is not going to be present within, let's say, the police force or the CPS or even judges, which may mean the application of criminal law to this kind of thing, I mean, it might not be very good, and we may end up with sort of a very haphazard, unsatisfactory picture if this is to become a thing. But then again, the argument the other way would be that if it's not underpinned by criminal law, it might just be too easy, and then we deal with, I don't know, civil penalties in the forms of low fines, for instance. Sometimes the cost of non-compliance might be a price people are just worth paying. They think, okay, I'll get fined X amount of money for doing this, but what I stand to gain is actually a lot more, so it's just a price I'll pay. So yeah, again, there's another interesting discussion to be had about exactly how it would work in that regard. So the short answer to the question was yes, I think.
Excellent. Here again, you have interesting legal comparison, I think, what's going on in corporate law, for instance. You see more and more criminal law integrated, and not necessarily only in the UK, but internationally. So criminalization of a number of corporate related actions. Do we have cases already?
Yeah, there is one very significant case that happened. An even bigger problem with this, actually, this area, is that we already see, particularly the tribunal system, making decisions which suggest they don't really understand how anonymization works. So there's a very famous case that is widely regarded by people in the field as being a bit of a car crash, really, involving a clinical trial undertaken by Queen Mary University of London. So it's the case of Alan Matthees and Queen Mary, which involved a person making a freedom of information request to Queen Mary in relation to it's an infamous clinical trial that was very dodgy for all sorts of reasons. So they wanted to get the data from the trial to scrutinize it and show that the Queen Mary's methodology was no good. Queen Mary didn't want to disclose this data because it's full of medical records of people, basically. So they said, no, it's not anonymous. There's a high risk of it being de-anonymized if we send it to you. So no, you can't have it. The applicant then appealed to the Information Commissioner and went through the appeal process all the way up to the tribunal, saying, no, it's not personal data, it's anonymized, I should be able to have it. And despite a lot of expert evidence saying, no, look, there's a very high risk that if this gets disclosed, it's going to be de-anonymized and used for all sorts of very dodgy purposes, the first tier tribunal said, no, it looks fine to us. And the ratio for that decision was based on a very questionable understanding of anonymization. Basically, the tribunal's understanding of anonymization that comes out in the judgment is divorced from the authoritative computer science understanding of anonymization. The court said, the tribunal said, yep, it's anonymous now, therefore it will be forever, disclose it, when actually that's probably not the case. And so basically the tribunal made a decision that's divorced from how anonymization should be understood, ordered the disclosure of this information when it really shouldn't have been. And as far as I know, to date, the information that was ordered to be disclosed has just been uploaded to the internet, and you can go and download it right now if you want to. And that's the exact type of situation that really shouldn't happen. So when this was a big part of my PhD, really. This whole I used as a use case to show, look, this is exactly why the law needs to be changed, because that is so wrong. It should never happen. And it's a prime example of why, in that situation, the person requesting the data had a perfectly valid reason for wanting it. And if it had just been shared with them specifically for that purpose, there would have been no problem. But instead, it was shared with this person who then went straight online and uploaded it for everyone to download, which should never have happened. But under the Freedom of Information Act at the moment, the courts are not able to order limited disclosure. Once they decide the exemption doesn't apply, all they can do is say it has to be released openly. And that's just no good. It's no good.
Here again, thank you so much, Henry. That's fascinating. It tells a lot of things. It tells also about the training, you know, of the judges, and because these fields are really new, so we also need to understand from legal and other points of view how it works. So there's a lot of work which is interdisciplinary, a lot of work for us, and that's going to be the conclusion, I suppose, of today's webinar. These are interdisciplinary webinars, so I'm sure we'll have lots of discussion with our colleagues in tech, in medicine, in different disciplines. Thank you so much again, Henry. That was really very interesting. It has been recorded. It's going to be on the website pretty soon, so you can watch it again. And I'd like to thank everyone, in particular the team from Olga, Marika, her, Claudia, and Andy, obviously, for supporting these webinars. I'll see you next week with another fascinating topic, plastic in the ocean. Thank you very much, everyone.
Thank you very much. Bye.